This topic is forensic expert witness and the court. Forensic expert witness and the court. It should be noted that the crime scene investigator has a greater chance of ending up in court than does an average professional. So he appears in court as an expert witness. So before we move on, there's a question we should give answer to. Who is an expert witness? Who is an expert witness? An expert witness is a person with extensive knowledge or ability based on research, experience, or occupation in a particular area of study. Experts are called in for opinion on their respective area of study or occupation. So, you are called as a forensic investigator. When you are called as a forensic investigator to come and testify in the court, because of your knowledge in the evidence or in the investigation that you have carried on, what you are giving at that time is an expert opinion. And an expert opinion is a belief or judgment about something given by an expert on the subject. So, an expert witness can provide the court with a statement or a statement of opinion on an admissible matter, calling for expertise by the witness if they are qualified. If they are qualified to give such an opinion, because at times the court may disqualify the supposed forensic expert from giving evidence, from testify to any evidence. So, an expert witness must help the court to achieve the overriding objective by giving an opinion that is objective and unbiased concerning matters within their expertise. Within their expertise. We said something. We said, I said the expert must be qualified to give such an opinion. He must be qualified to give such an opinion. Then that will take us to another question. What are those things? Or let me just put it like this. What are the tests of admissibility for an expert, for a forensic expert to come and witness in the court, to be allowed to witness? Now, while different nations, we have slightly different rules of admissibility. Generally speaking, an expert testimony is admissible if, number one, the knowledge of the expert will assist the trier of fact to either come to a determination about a fact in issue or understand the evidence in the case, and the testimony offered is based on sufficient facts or data. So, if the knowledge of the expert will not assist the trier of facts to either come to determination about a fact in issue or understand the evidence in the case, then such an expert witness may not be allowed by the court to testify. Another test of admissibility is that the opinion or conclusions must be based on principles and methods considered reliable in the scientific community. That's number two. And another one is that that's number 3. The reliable principle and methods we apply reliably in the case at bar. So it must be relevant to the facts in issue, in dispute in the lawsuit. Then I will say number 4, proper qualification. The witness must be duly qualified as an expert on the matters about which the opinion being sought or about which the opinion being expressed. I was saying proper qualifications. So the witness must be duly qualified as an expert on the matters about which the opinion is being expressed. Such expertise can be acquired through formal academic studies or simply as a matter of substantial experience. There are some because of the fact that they've been working like, let me say, like apprentice. Let me use that word. They'll be working with an expert in a lab or in a forensic lab, and after a period of time, they have acquired a kind of experience that they too can do what the one that has been tutoring them or guiding them or mentoring them, they can do what he or she can do also. And also, there are some people that there are some other method of acquiring such kind of education or training, like the one we are doing now. So, it can, the expertise can be acquired through formal academic studies, as you have in regular university or higher institution of learning, or simply as a matter of substantial experience. Then other rules of evidence may also come into play. Like in our country here in Nigeria, the court will also consider evidence as 2011. So all these things together will be considered by the court before an expert can be allowed to witness. So the evidence Act 2011 will be considered in Nigeria, while in nations of the world like US will be considering evidence rule 702, federal evidence rule 702, and maybe some other one like Dubat rule. So in our own country, I mean in every nation of the world, there are different things they consider. There are different rules of admissibility. So, but generally speaking, what we have mentioned will come into play. That is the knowledge of the expert. If the knowledge will help the matter, the fact will help the court in the trial of the fact, then if there is sufficient data, sufficient facts or data, if what the knowledge that the expert is bringing is based on sufficient facts or data, then if the method that he used is reliable and the method is accepted, is something that has been accepted in scientific community, then with proper qualification of the experts, all this will be considered before it can be allowed to testify. So let's move forward. Let's move forward. We have two types of report. In fact, the reason why any investigator carry out his investigation in the first place is for him to come and give report of his examination of investigation, so that such work or such an expertise can be used to help the court to take decision. So, and we have two types of report. We have written report and oral report. Written report and oral report. Let's talk about written report first. Written report include all the relevant information in a clear, concise, structured, and unambiguous manner as required by the relevant legal process. Though there is no rigid way of writing a report, of writing an expert report when you are giving opinion. There's no rigid way of writing your opinion, of presenting your opinion, but there are some things that must be included. Generally speaking, there are some things that must be included. Number one, for example, the name and address of the investigator or the examiner, for that forensic examiner or the forensic investigator must be included. The identity of the forensic investigator, whether it's a crime scene investigator, whether question document examiner, whether fingerprint examiner, or which this identity and evidence of their status and qualification where this is required. In fact, it is necessary that it must be there. Your qualification must be there because it must be part of what you part of the report. The reason is that your qualification will convince the judge that you are qualified to testify, to give testimony in this case. So, this kind of qualification may be the academic qualification that you had. Then it may be the one that you also have as a result of your training, the training you have because of that particular investigation. For example, if you are giving testimony, if you're an expert witness for crime scene investigation, then the certificate, the training that you have undergone, the certification that you had because of that training must be part of the written reports. So if you have more 2, 3 just certification on the same subject, let it be part of it. Let it be part of your CV that will be presented. And if you are writing a different CV, that you want to attach to the report, let it be those things that are relevant alone. Whatever that is relevant alone with the case is what should be inside the CV. It shouldn't be like the general CV where you have many of those things that may not be relevant to what you are testifying for. Then another thing that must be there is the signature of the investigator. The signature of the investigator that shows that he wrote it and he wrote it intentionally, that the report was not written by another person but by him. Then Another thing that must be there, very important, is your publication. Your publication. If you have ever published in any journal, let it be part of it. That's part of what the court will use to judge you as an expert. Your publication, whether you have written a book on that subject, or whether you have presented a paper in community of scientists, or among people that practice the same thing. So you attach this one, let this one be part of it, part of your CV. And this is one of the reasons why I always encourage our members in forensic investigator society in Nigeria that when they present paper, they should also make it publishable so that it can be published in our journal. So publication is key. Publication is key. Then another thing is that must be included is the purpose of the expert involvement in the case. Let it be there. The reason why you conducted the investigation or the examination, let it be there. Then after that one, you write the details of the investigation that you carry out. Then inside the investigation, the opinion that you express must be written separately so that it can be seen. In fact, the best way, the way I used to do my own is that after all the information, the first information that I mentioned, then the detail, where I written the detail of the investigation, the opinion will be stated first. I used to state the opinion first, then the reason why the opinion was like that, then it will be on the second page. Then if it is something that involves that can be explained diagrammatically, then I put it there in a way that by the time I said it to even a layman can read it and understand it. Just simple language that be devoid of any jargon. So any layman can read your report and understand it. So when you send such a report to the court can read it, and without calling you, understand what the message you are passing across. And you must make sure that an expert opinion should be devoid of any you are giving an expert opinion, but you are not deciding for the case. You are not telling the court that this person is the person who has probably somebody has hired you. You are not saying that person is guilty or not. It's not your job to say he's guilty or not. Your own is to give expert opinion, and the court is in liberty to accept what you said, what you have written, or to reject it. So you must be neutral, even though you have been paid, but do not go beyond your boundary. It is the duty of the court to decide whether a man is guilty or not. Now, let's leave that one, the written report. Let's go to oral report. At times, you may need to appear in court. The court may decide that the expert witness should come and explain the reason for his opinion. So while you are doing this one, you need what we call court demonstration. Court demonstration. In most forensic investigation, you will need what we call court demonstration. That is, you will, for example, now, if what you have, you maybe probably you work on fingerprint. You work on fingerprint, so you can the way you work on those things using your system, or if you are using manual, you can screenshot, or you can screenshot those things, screenshot it on system and upload it to your PowerPoint, or you snap it. If you use manual, you snap those pages out, the stages, the process that you pass through before you arrive at conclusion. You snap it, upload it onto your PowerPoint, then you explain it. But make sure that your screen is not worded. Just simple words that you can explain, and as you're explaining, the diagram will be there. As you're explaining, the court and all other people within the court can go along with you. So as you're explaining, we understand. If you use simple language and you make sure that your screen is not worded, it's not too worded to the extent that people will be reading and at the same time listening to you. No, just make sure that you have short, straight, concise information on the screen, and the diagram must be able to explain themselves, apart from the fact that you yourself that you are going to say one or two things about them. So, and your appearance also is something that you should take note. When testifying or appearing in a court, the investigator should have a presentable appearance. I recommend that a male should wear a clean shirt, tie, and suit, or sport jacket. A female should dress neatly, maybe in a suit or a skirt and a blouse. Something like a high brow, nose ring, bogus long chain, lips, or tongue ring should not be worn, because the court operates in a formal environment, and the opposing side and the judge are watching the witness dress, appearance and manner, and presence of mind. And when you dress in a way that may make people to be doubting whether this one will have integrity, then you may put your testimony at risk of not being accepted. So don't dress in a manner or talk in a manner that will make them to be doubting your integrity. So the investigator should speak clearly and loudly to be understood by the attorneys and the judge, and do not become fidgety. He must answer all questions put to him by the opposing attorney or the judge truthfully, and be as brief as possible. If he does not know the answer to a question, he should say so. If he does not understand the question, he may tell the attorney to repeat or clarify the question. He should take time in answering the question, because his attorney may want to update the question. Expert witness should be allowed to tricky questions. He should not allow the opposing attorney to put words into his mouth. Then watch out for the same question asked in the different words. So, and do not give information that you are not asked for. Do not volunteer any information. Ask the question they ask you truthfully and be brief. So, on oral evidence, it's possible that you might have sent a written of evidence before that time, and now the court asks you to come and give and explain what you have written there. So be careful so that your word will not be, you won't have any contradictory statement from what that you have already written. Before we stop, there's something very important that we like us to talk about, and that is chain of custody. Chain of custody. Chain of custody is a legal term that refers to the chronological sequence and documentation of how evidence is handled, who collected during an investigation. So the chain of custody is very, very important for proving that evidence is reliable and admissible in court. The procedure for establishing a chain of custody starts with the crime scene. And in fact, in laboratories, apart from the chain of custody that is accompanying the evidence, within the laboratory, the chain of custody also must be maintained, so that you can know who and who handles or did the analysis within the laboratory. At a particular time, you can know we can know where the where and who is in charge of the evidence. And there are reasons for chain of custody to be maintained. There are reasons for this. And let me just tell you, there are about 4 of them that I will mention. The importance of chain of custody. The chain of custody must be maintained to prevent the following. Number 1, substitution of evidence. If chain of custody is not maintained, the opposing attorney may still prove that substitution of evidence was possible, that it probably it has been done, that it is not the same evidence that was taken from the crime scene that was brought to the court or that was analyzed. Another reason for chain of custody is to avoid tampering of evidence. It is possible for a corrupt officer within the laboratory or among the team, among the investigating team, to tamper with the evidence. For example, a DNA, if a DNA is taken from the crime scene, a corrupt officer may just a drop of dick in a DNA will destroy the whole thing. Or it might be diluted with some other chemicals that will render it useless, that will degrade it. So, to prevent tampering of evidence, we must maintain chain of custody, and also for the opposing lawyer not to prove it that the evidence has been tampered with. Another reason is that is to avoid mistaking the identity of evidence, because at times, because of workload in some laboratories, it is possible for evidence A from a crime scene A to be mistaken for another evidence B from crime scene B, because it may be both of them may be the same type of evidence. Maybe fingerprint, both of them are fingerprint from different crime scenes. And they brought them in by the same, maybe by the same, using the same type of bag. Maybe both of them are brown envelopes. Brown evidence bag. So it is possible for mistake to occur if chain of custody is not maintained. So to avoid mistaking the identity of evidence, it must the chain of custody must be maintained. And lastly, to avoid altering of evidence, an evidence may be altered. For example, fingerprints before analysis somebody, a corrupt officer might have destroyed a tangible part of it that will make it readable. If it is not readable, then the examination will be inconclusive, and that will destroy the result. Or even the fingerprint might have been changed from one fingerprint to another fingerprint totally. So these are the reasons why the chain of custody must be maintained. So establishing the chain of custody is made of both chronological and logical procedure. So from the crime scene to the lab, it must be maintained. Within the lab, it must be maintained. So we are stopping here.